I'm Lee Pacchia with Mimesis Law. Last week, General Motors released the findings of a 3-month-long internal investigation into faulty ignition switches that affected millions of vehicles. Join me now to delve into the problem and what it all means. I'm happy to say we have Professor of Law at New York Law School, Robert Blecker. Good to see you. Thanks for coming and see us.
Nice to be here.
So, let me start off by saying this is a tragedy. 13 people died almost as a direct result of General Motors' failure to disclose that there was a major problem with the ignition switches on millions of vehicles. That said, it's also not unprecedented. What's wrong with the response that the automaker has had thus far? They've essentially set up a claims process that's going to be overseen by Ken Feinberg, where people are going to come and present their case for compensation, and Ken Feinberg's going to make a decision as to how much they're entitled to, and everyone's going to move on with their lives. That's a system that we've seen play out in instances of corporate malfeasance over the years for quite a long period of time. What's wrong with that?
Well, there's some things that are right with it, but what's wrong with it is there's, first of all, one group that's not going to move on with their lives. They don't have lives, they're dead. At least 13 people have been killed as a result of this, and probably more. A second thing that's wrong with this is that we're thinking of it in the way that you put it, as a tragedy. And it is a tragedy, of course, but it's something other than a tragedy. It's something more than a tragedy. It's a crime. It's a serious crime. And it may be that the victims' families will be compensated by money, but we, society, will not have adequately responded unless we understand it for what it is, which is a serious crime, and unless we respond to these serious criminals with appropriate punishment for several reasons.
You read the investigative report. It's over 300 pages long. What jumped out at you when you went through it?
What jumped out at me was that they gave us the vocabulary to understand it as a crime, although they never talked in criminal terms. The report pointed out that there was a whole culture of the avoidance of responsibility that pervaded General Motors. The report pointed out the consistent failure of people to do what their job was. Engineers who were involved with safety, lawyers who were also involved with safety. That is to say, again, thinking of it as a crime, do we have the appropriate tools and the vocabulary to treat it as such? And we do, and the report gives us those tools, the vocabulary. For example, they point out consistently about what people didn't do. They can't find the smoking gun except for one engineer who first approved an ignition switch that did not meet specifications, even minimal specifications, then became aware, apparently, that that ignition switch was deadly, and substituted a different ignition switch which did meet specifications and did not change the number on the part.
So the other engineers didn't know?
Yes, they didn't know from just reading the manual and the part numbers. They could have known had they done what one of the plaintiff's lawyers did, and that was to X-ray a more recent ignition switch where the cobalts were not crashing post-2009, and contrast it with the ignition switch from the 2006 and 5 and 4 cobalts where they were crashing, and they would have seen that though the two parts had the same number, they were different parts.
So the plaintiff's attorney was the one who actually figured out what happened here?
That was one source of figuring out what happened, and a primary one. An accident investigator working for the state police in Wisconsin also diagnosed what the GM engineers didn't and issued a report about the fact that when it didn't have enough torque, we'll skip the technicalities, but the point is that when the ignition switch would go into the off position, which it would through no fault, through a leg brushing against it, not only would it turn off the car, but it would disable the airbags. So the car would have the engine not on, and if it would crash, the airbags wouldn't deploy. He diagnosed that. He issued the report. The report was buried. Now the point is that the present GM report shows the failure to act consistently, except for this one engineer who under oath has claimed he doesn't remember doing this, though he did it. Everyone else's was a failure by committee. But failure, an omission, the failure to act can be the basis for criminal responsibility. An omission constitutes an act if and only if a person has a prior duty to act. That prior duty can come from the relationship in the company. engineers, safety engineers have a duty to act, a duty to perceive. Now, what's their culpable mental state? We have a tendency to say, we should handle this through civil compensation because that's all it is. It's a terrible tragedy. And it is, of course, a tragedy and not a crime. But it is a crime. And we have the culpable mental states. No, there was no intent to kill anybody. But there was clearly criminal negligence. Negligence is the failure to perceive a substantial and unjustifiable risk. That failure has to be grossly deviant from what a reasonable person would do in that situation. A reasonable safety engineer, a reasonable committee that's supposed to be in charge of this stuff, would have seen the danger, and their failure to do so constitutes negligence. There's also a suggestion in the report, and the report details this, that they tended to characterize this whole thing as inconvenient, customer inconvenience. I want to see if I can find exactly the phrase they use. Rather than safety, it was considered a customer convenience issue that the airbags wouldn't operate. Had they labeled it,
that's a legendary moment in corporate speak.
It should be, shouldn't it?
Yeah.
Because had they labeled it, we're just talking about labels now. Had they labeled it a safety issue rather than a, quote, customer convenience issue, then cost-benefit calculations are not applicable anymore. Safety, the manual says, and the corporate culture says, if it's a matter of safety, then you don't ask how much does it cost. Supposedly you protect. So they labeled it customer convenience. They specifically adopted a whole vocabulary so as to avoid alerting customers to come back and get their switches replaced unless they had complaints about the crashes. They had a whole manual in which they passed on the appropriate kinds of vocabulary. They were trained, employees were trained to avoid the word defect and substitute the phrase does not conform to design, so as to obscure from the owners that they had defective cars. They were trained to not use the word problem and instead use the words issue, condition, and matter, these neutral, bloodless sounding terms, again, not to alert. The lawyers for GM, when they were aware that they had a damning case against them where the plaintiff's outside experts showed that that GM had replaced the ignition switches and not alerted and recalled the cars with what they knew now or should have known were deadly ignition switches, when they discovered it, so then the settlement committee said settle it for $5 million. And attached as a condition of the settlement a non-disclosure, which meant that other people wouldn't be alerted. Now, if you take all this stuff together, what you've got, it seems to me, the bottom line here, is you've got either negligence, criminal negligence, or you've got criminal recklessness. Recklessness is the awareness and conscious disregard of a substantial and unjustifiable risk, which is grossly deviant. Now, what you might not have is a causal connection to a specific person's death from a specific GM employee's act or omission. So you might think, well, so they can't prosecute for homicide because you have to prove that the defendant caused the death of one of the victims. But there are other crimes. We have a crime called reckless endangerment, which is if you act with a culpable mental state of recklessness and you create a substantial and unjustifiable risk of death, whether or not anybody gets injured or killed, you've committed the crime of reckless endangerment. That's a year in prison.
Just to be clear here, are we talking about punishing individuals for what they did, or are we talking about punishing the corporate entity on the whole?
That's the main point. I'm delighted you asked that. We're talking about people acting negligently, criminally recklessly. We're talking about punishing individuals for one of two, well, three really, principal reasons. First, deterrence. Boy, if there's any group that is deterrable so this won't happen again, just let a couple of GM engineers and lawyers and corporate executives go to prison for a few years, and you will see a massive change of behavior overnight. They read the manuals, they read the newspapers, everyone will be very aware of what happens. So if your perspective is that what justifies punishment is deterrence, well, here is the way to get your maximum bang for the buck in terms of deterrence. Or it could be denunciation. That is, it would provide us the appropriate occasion to collectively denounce this kind of behavior and say, this is not acceptable, this is not what we are about, and we won't tolerate it. And finally, for me, retribution is ultimately served. That is, these people deserve it. Let's not forget about, we've got at least 13 dead people. I don't know how many maimed, permanently maimed and wounded that we have. These are people who have been denied their lives, have been denied the quality of their lives. Those who operated with such callousness, such coldness, who substituted a cost-benefit calculus for the lives and suffering of individual human beings deserve to be punished.
So what you're actually suggesting is punishing individuals for their role in this tragedy. That is a departure from the way things have been handled historically in this country. What needs to change in our society to get to where you think we need to be?
You know, it's interesting you say that. It is a departure in terms of corporate conduct as a response. It is not a departure in terms of street conduct. There is fundamental hypocrisy going on here. There is one code for the street and one code for the suite, the corporate suites. And that's got to change. And the guys I've interviewed inside prison expect this. They wouldn't expect prosecutions because these people pay taxes. These people are, quote, legit. They're still taking lives. They're still acting with the same callousness and coldness and wantonness. And by the way, this has been abetted by appellate courts. New York Court of Appeals disgracefully adopted two standards of causation. One for street criminals and then one for corporate criminals, and they did it unabashedly. What's got to change is we have to, as a people, come to understand that one system of law should govern, that people should be judged by their culpability and by the consequences that they cause. And people who cause the deaths and danger to innocent citizens and do so with a callousness and a wantonness and a recklessness and a negligence deserve to be punished regardless of whether they wear white collars or red collars or no collars at all.
Robert, always a pleasure. Thank you for stopping by.
Thanks for having me, Lee.
That's Professor Robert Blecker from New York Law School. If you'd like to see more of the stuff New York Law School is working on, be sure to go check out their YouTube channel. You can always follow them on Twitter. I'm Lee Pacchia. Thanks for watching.